Inclusion for application. Yes. Second appeal, hearing. Paper books are ready. No. Question is, paper books are ready. The matter can be heard out. Where? No, appeal is admitted. So you have filed an application. Okay, give the slip. Application or yes. Okay, to be mentioned, correction. Oh, restoration. Have you served copy upon the other side? Yes, give the slip. Inform the other side also. Yes, call the list. Yes, pass over. Okay, not today and tomorrow. Yes, pass over.
Your Lordship, I am for the petitioner item 4, my Lord. I am for the petitioner item 4.
Yes. It is appearing for the first time.
Yeah, appearing for the first time.
Give the records.
Yes, Your Lordship. The petitioner before Your Lordship are the defendants. Your Lordship, may I, my Lord?
Where is the order? Let me see.
Yes, my Lord. The certified copy lastly I have annexed. I have come up against my Lord rejection of my application under Order 7, Rule 11. The order dated 11th of
Have you filed written statement?
Yes, my Lord, I have filed. I have annexed the written statement as well, my lord, at page 25.
Yes, what is your ground of this application?
Your lordship, my application is under Order 7 Rule 11D
No, no,
particularly. I have taken the
what is the ground of challenge in this application?
I have come up as because the learned court below has taken into consideration the date of the knowledge of the plaintiff. In my humble submission, that is not relevant as per Article 76 of the Limitations Act, if I may say, my lord.
Article 76.
Art 76, yes. For
Yes.
compensation for slander, it is 1 year when the words are spoken or if the words are not actionable in themselves when the special damage complaint of results. So, in my respectful submission, the instant defamation suit has been come up against an alleged post made by the erstwhile daughter-in-law of the plaintiffs, who are the opposite parties herein, which has been made in the month of January 2017. So it has to be, my lord, filed within that the date of knowledge. In my respectful submission, the date of knowledge of the plaintiff is irrelevant herein. If your lordship kindly takes up the plaint itself, it is for suit for damages and compensation for defamation and slander. At page 16 of that is the plaint, suit for damages and compensation for defamation and slander.
Yes, the defamation took place when?
In the month of January 2017. That they have not admitted, although they have not admitted in their plaint, they have made a vague statement in paragraph 17 at page 19 that in the year 2017 some statement has been made,
No,
but
paragraph.
no particular.
No.
17, page 19,
Page 19, paragraph?
17.
Yes.
Sometimes in the year 2017, but the cause of action arises, my lord, in my humble submission, when the alleged post had been made.
So anyway, that has to be taken in your written statement. The preliminary issue will be framed from the stage of at this stage. It cannot be decided. You frame, let a preliminary issue be framed on the basis of your written statement. Yes, take down.
Then, my lord, may I humbly beseech your lordship to grant me grant the learned trial court to frame an issue on particularly on this point.
Anyway,
In addition,
Learned advocate for the petitioner plaintiff is present. Our learned advocate for the petitioner plaintiff. This application directed against the order dated
11th of April 2025. Order number 21 dated
11/4/2025,
11/4/25.
passed by the learned Civil Judge Senior Division, Siliguri, in money suit number 45 of 2018. Stop. Plaintiff, the defendant petitioner being aggrieved by the order dated 11/4/2025, he has come up, the defendant petitioner in money suit 45 of 2018, being aggrieved by order dated 11/4/2025, by which the learned trial judge was pleased to reject the application under Order 7, Rule 11, read with Section 151 of the Code of Civil Procedure, has come up with the instant application. It is the learned advocate submits that the learned trial court erred in proceeding with the suit and by rejecting the application when the suit is barred by the limitation. Learned advocate also draws attention to which paragraph?
Paragraph 17, page 19, paragraph 17.
Yes, to paragraph 17 of the plaint, where plaintiff stated that plaintiff noticed in the year 2017 a posting in the Facebook which is defamatory in nature. Stop. Learned advocate submits that the allegation is not specific and cannot be acted and cannot be taken cognizance of. Upon producing the grounds of this application and the order passed by the learned trial judge and the provisions contained in Order 7, Rule 11 of the Code of Civil Procedure, this court is of the view that as per plain reading of the plaint, the provisions under Order 7, Rule 11 is not complied with. Thus, this suit cannot be dismissed, plaint cannot be rejected under Order 7, Rule 11 of the Code of Civil Procedure. Thus, this court does not find any error in the order passed by the learned trial court. Stop. However, the plaintiff is at, however, the defendant petitioner is at liberty to pray for framing the issue with regard to the maintainability and to proceed accordingly. This revisional application stands disposed by affirming the judgment and order dated
11th April 2025.
11/4/2025,
25.
money suit number 45 of 2018.
Yes, ma'am. Great.
Yes, item next. Yes, item 5. Yes, where is this order under revision? Yes, 11/9/2025. Yes. So there was a direction to serve copy by this court. There was no direction. Have you filed any caveat? Then you say How can the court can direct? No, question is, you see, there was no caveat. So how the court can direct? So what is the relief you are seeking? Yes.
The page number 30,
Yes.
the application for substitution
Yes.
has been rejected by the land.
Yes.
That order still subsisting.
Yes. So you are the plaintiff applicant.
No, I am the defendant.
Yes.
Now, since the application for substitution has been rejected,
Yes.
that is still pending.
Yes.
It is subsisting.
Yes.
On page number 32,
Yes.
the plaintiff, there is some defendants had died and their name has been expunged, and accordingly, court directed them plaintiff to file the amended plaint.
Yes.
Now, while filing the amended plaint is given in page number 34.
Yes.
They surprisingly made defendant number 24 A, B, C, D, who has substituted, has been rejected. Their name has been included.
So this is okay. Amended plaint has been filed. There are certain irregularities in the amended
Plaint. We have raised objection in
Bad,
the
bad.
amended plaint itself.
That is, and your objection was rejected.
Now, admission was engrossed in the amended plaint itself, but that is not considered. But amended plaint is accepted.
Oh, what is the order? 10/9/2025.
In the last portion of the order, the amended plaint is hereby accepted and the same be kept in the.
What was your objection? Written objection?
Written objection is not, on that date they had filed. We have engrossed the objection.
What is the objection? Specific objection?
Specific objection is that this defendant number 24, whose name has been included in the amended plaint.
Okay, you serve him a copy, let it be taken up day after tomorrow. Yes, record an order. Learned advocate for the petitioner is present. Yes, what is your name? Mr. Orijit Ghosh, who intends to represent the opposite parties, is present. Let copy be served upon Mr. Ghosh. Let this matter appear on 19th,
in Friday.
okay, 19/12/2025.
Both only 19, then on that date it will be adjourned, not today.
Okay.
For the petitioner, my lord, seeking transfer of a case, my lord, from Alipur, Kolkata Alipur to Alipurduar, my lord. Copy. Direction be given to serve the copy.
Yes, record an order. Learned advocate for the petitioner is present. This is an application under section 24 of the Code of Civil Procedure filed by the petitioner. You are the petitioner plaintiff.
I am the petitioner plaintiff, yes, lordship.
Filed by the petitioner plaintiff.
Now, my lord, plaintiff, my lord, plaintiff is the husband, my lord.
Okay, filed by the petitioner seeking transfer of matrimonial suit number 2840 of 2017 pending before the learned additional district and sessions judge 11th court Alipur district South 24 Parganas to the learned district judge at Jalpaiguri. Stop. Let a copy be served upon the opposite party within 1 week. An affidavit of service be filed. Let this matter appear in the next circuit.
In the stay of the proceeding.
As the matter is sub judice before this court, Parties may seek adjournment before the learned trial court, which may be considered.
Item number 7, Lordship, I am for the petitioner. My request per your Lordship for expeditious disposal. This is a case filed in 2016 for preemption, your Lordships. Now, in this case, that is the stage of cross-examination of PW3. Now, your Lordship, 8/5 to 2024, Advocate Commissioner's witnesses, your Lordship, PW3. And now, your Lordship, till today, only adjournment. Kindly looks the order sheet, your Lordship. I am filed entire order sheet, your Lordship. 2016 to 2015. In the list of dates, I categorically mention, your Lordship, 21 January 2026.
So it is your case, preemption case.
Yes, Lordship. I am for the petitioner. Now, Lordship, cross of PW1 3 years, your Lordship. Now, PW2 examine 9/1/2023 and complete 12 September 2023. Now, 18/5 2024, PW3 is present. That is Advocate Commissioners for local inspections. Now, that is the next date is 17 February 2026, cross of PW.
Yes, record an order.
Lordships,
Learned advocate for the petitioner is present.
and order
This is
17,
an
your Lordship,
application,
three
the
adjournments.
petitioner has moved this application for an order directing expeditious disposal of the preemption case being Miss P case number 37 of 2016 pending before Learned Civil Judge Junior Division Jalpaiguri. Top. Upon considering the nature of relief prayed for, this court is of the view that no fruitful purpose will be served by directing service of notice upon the opposite parties. Stop. Thus, this application under Article 227 of the Constitution of India stands disposed by requesting the Learned Civil Judge Junior Division, Jalpaiguri, to dispose of Miss P case 37 of 2016 expeditiously and preferably within a period of 2 months from the next date fixed,
Lords, get
without granting
Lordship,
unnecessary
if your Lordship
adjournment.
direct for mandatory directions upon the court.
Why, no,
No adjournment to either party, your Lordship.
no, without granting unnecessary adjournment. I've recorded that.
No adjournment to the other. Either OP always preferred a time petition. Every order sheet says.
No,
your
I've
Lordship.
made it clear
Lordship.
without granting unnecessary adjournment.
Lordship. কি দিচ্ছি দুটো মামলায়। Lordship, in item 8 is the matter is same. That is the stage of DW. And now see DW is fixed for 10/12/2024. 1 year, no DW. Only adjournment.
Now, when is the next date fixed?
Next date, your Lordship, today. But today's court is PO is on leave, Learned PO. So I'm Lordship, this matter is the same
is also
preemption matter,
preemption.
your Lordship. And the order sheet
Before the
says-
same judge?
Same judge, your Lordship.
Okay,
But
record
order
on-
sheet- Lordship, order sheet says, your Lordship, PW1 3 years, PW2 1 year, PW3 one and a
Yes.
half years, DW3 4, DW for 10/12/2024.
Learned
1
advocate
year,
for
your
the
Lordship.
petitioner
No
is
DW.
present. This application is moved for a direction upon the Learned Civil Judge Junior Division Jalpaiguri to dispose of Miss P case number 36 of 2016 expeditiously. Stop. Considering the nature of relief prayed, this court is of the view that no fruitful purpose will be served by keeping the matter pending and causing service of notice upon the opposite parties. Stop. Thus, this application under Article 227 of the Constitution of India stands disposed with a request upon the learned Civil Judge Junior Division, Jalpaiguri, to take effective steps to dispose Miss P case number 36 of 2016 expeditiously and preferably within a period of 2 months from the next date fixed.
Lordship, one indulgence.
Yes.
Lordship, today the date is fixed. Now in natural courses, this next date is fixed for April or May.
Whatever it is,
Lord-
unless
Lordship, my
the
humble-
date comes,
On my humble request, your lordship, by put up, we file the.
it's better,
order.
you see, let a similar order be passed, okay? Within 2 months from the next date fixed, without granting any unnecessary adjournment.
Lordship, DW 1 years, DW, no DW, your
No,
lordship.
no, I made it that 2 months.
Lordship. নিয়ে নাও।
Well, the impugned order, Millard, is an order rejecting my application under order 26 rule 9. So Millard, an application, Millard, I'll just give a lordship a brief backdrop of the case, Millard. The plaintiff's land, Millard, it's a key grant leasehold
It is
land,
appearing for the first time.
appearing for the first time.
That's
So Millard, it's a suit for Millard eviction and recovery of possession. Millard, the defendant, Millard, allegedly has Millard trespassed upon approx 1 acres of land under the T grant area. And order 26 rule 9 application was preferred, Millard, for making a local investigation as to whether the land which Millard the defendant is occupying is Millard within the T grant area or outside it. And this application, Millard, has been rejected.
Yes, record an order. Learned advocate for the petitioner is present. This application is directed against order dated 27/2/2025, passed by Learned Civil Judge Junior Division, Alipurduar, in TS 64 of 2012. Stop. The Learned Trial Judge, by order dated 27/2/2025, was pleased to reject the prayer of the petitioner plaintiff for appointment of a commissioner under order 26 rule 9 of the Code of Civil Procedure. Upon perusing the petition and considering the nature of the suit and the order passed by the learned trial court, this court is of the view that this application should be admitted. Thus, I admit this application. Let notice be issued upon the opposite parties within 1 week. An affidavit of service be filed forthwith. Let this matter appear before the next circuit. Pending hearing of this application, there shall be stay of further proceedings entitled suit 64 of 2012, pending before Learned Civil Judge Junior Division, Alipurduar, for a period of 4 weeks after vacation.
Millard, let it be 8 weeks, Millard. So hopefully by that time it will be disposed of also.
Then I make it 8 weeks from today
8 weeks from today, yes.
for a
Yes.
period of
8 weeks from.
8 weeks from today.
Yes. I'm grateful, Millard. Service contract. The service contract.
My lords, item number 10, I appear for the petitioner. May I please, my lords? My lords, for item number 10, I appear for the petitioner.
Yes.
May I please, my lords? My lords, here the husband, opposite party,
Application
can as my lords, they had filed one can for vacation of interim order. There are a lot of orders which have been passed by this court, my lords, in this case.
No, what is this can do?
Can 2, my lords, was preferred by the husband for vacation of interim order. A stay was granted in this case.
I appear, my lords, for the opposite party husband, my lords.
May I just give you a brief background of the case, my
What is
lords?
the order? What is the order under challenge?
impugned order, my lords, is at page number 17. My lords, the husband had filed a suit for restitution of conjugal rights under Section 9 of the Hindu Marriage Act. And along with that, he had preferred an application under Order 32, Rule 15 of CPC, which was allowed without inquiry, my lords, by the district court. Subsequently, my lords, by an order dated 22nd May, Senior Advocate Mr. Mojumdar was appointed, my lords, as a mediator to work out a solution. Now, subsequently, on 6th November, my lords, the report was also filed before the court. And pursuant to that, on 7th November, my lords, directions were passed. Kindly take the order dated 7th November, passed by this court, my lords.
What is the order under challenge before this?
That is page number 15, my lords.
Page 15.
17, my lords, I'm sorry, 17.
Page 17, yes. No, what is, let me see the revisional application.
Yes.
So this is the order under challenge.
Yes, my lords.
Yes.
My lords, this order was stayed by the order dated 19th February 2025.
Yes.
Subsequently, my lords, the court appointed a mediator, and the report was also filed before this court. And on 7th November, my lords will see order passed by Justice Bishwajit Basu, my lords. 7th November, my lords.
Yes.
My lords, pursuant to this order, we went to the North Bengal Hospital, my lords, for an inquiry, my lords, for an investigation. My junior will hand over the prescription, my lords, submitted.
No, mediator was appointed for the purpose of settlement.
Yes, my lords.
So what is the result of the mediation proceedings?
My lords, I do not have the report with me since it was submitted before the court in a sealed cover. But after that, my lords, on 7th, this direction was passed. And we are complying with this order. We went to the medical North Bengal hospital, my lords, for our examination. My junior will hand over, my lords, the prescription which was passed. What happened there was, my lords, I want to indicate the conduct, my lord, what is happening here, my lords. Kindly take the prescription, my lords, of the doctor, my lords. If my lords will take the first page, the informant is the husband and father there. My lords has it. And my lords, may I be permitted to read, my lords?
No, let me see.
Very well.
Yes, copy has been served upon your learned
Yes,
friend.
yes, yes, my lords, I have served them. Through email, I have served them. My lords, my lords, may I be permitted to make some submissions, my lords? My lords, what is surprising here is that
The question is,
the
on the basis of this report, whether,
medical board has been referred, my lords.
yes,
They have referred the matter to a medical board with 2 psychiatrists and 1 psychologist, and that will be held at the Department of Psychiatry.
now the question is, you see, prima facie certain inquiry is there, okay? Certain
Very
reports
good.
are there.
Yes,
On
yes.
the basis of this report, whether the order of the trial court should be varied or not, that is the question.
My lord, what I am submitting here is that
You are for the husband,
I am for the wife, my lords.
you are for the, now the question is, you see,
Yes,
the court has directed an inquiry and
yes,
thereafter appointment. Against
yes,
that, you see, you have come, against that you have come.
yes. My lords, what I am submitting is that
Yes,
my husband had preferred an suit for restitution of conjugal rights.
yes,
That was the main prayer in their suit, my lords.
yes,
By an order passed in this court, my lords, kindly take order dated 22nd May 2025. In this case, my lords, 22nd May 2025,
yes,
where both the husband and my client wife had appeared before this court.
yes.
And kindly see what he has said before the court.
What is the question?
22nd May 2025.
Yes.
My lords, kindly see the first paragraph. In compliance with the direction dated 21st May 2025, parties are present before me. I have interacted with them. The husband opposite party candidly proposes to restitute the conjugal life, and the wife also agrees to the said proposal. Subsequently, Mr. Sudipto Mujumdar, learned senior advocate, was appointed as the mediator and orders were passed, my lords. Now, he had come before the court, my lords, and he had candidly admitted taking me back to the matrimonial house. I was also of the same
Now,
opinion that
let me see the report of the mediator.
that was filed on 6th November 2025, my lords.
এটা একটু খুলে দিন তো। Yes, the mediator said that he had held discussion and the husband is ready to take her back. But
Yes.
some, due to some mental disorder, some medical
Yes.
attention is required.
But
And
my lords, what is happening today is that, my lords, in the prescription, if my lords will see, the
Yes.
entire thing was narrated by the husband.
You
He
see,
had
the court is not an expert. Whatever is there is there.
no,
Court can-
but my lords, what I am submitting is that in the petition they have not raised these allegations, and going there in front of the doctor, my husband is making all these allegations that I
Wait,
started hitting him.
The doctor has made his observation after treating the patient. Okay.
Yes,
Not that
yes.
unilaterally he had made this observation.
But
you-
my lords, the entire process is being hijacked by him, by the liberty, because the liberty is being granted by this court. This court has allowed him to be present there
No,
at the
no,
time of
Milords,
examination, my lords.
this is
And
very
he is
unfair.
going
This
there
is
and making all
very
these
unfair.
statements. He is
This
not
is very
allowing my
unfair,
father
Milords.
to speak there, my lords.
Very
He
unfair. Milords.
snatched.
This is very unfair. I don't know where these allegations are snatching,
No, my
etc.
lords, I have specific
Milords,
instruction from the
my
family, my
friend,
lords.
Milords,
I am not making these submissions from
my
the bar.
friend, let my friends file an affidavit if there are allegations
I
of
may do that, but that will
No,
not
when is
serve the purpose, my lords.
yes. Milords, may I just make a small submission?
when is the next date fixed?
Milords, no date has been
We have
fixed.
not. We
Milords,
have not been intimated of the next date, my lords. We have been told that we have to regularly inquire from them. So now we do not have the date
Now,
with us.
yes,
Milords,
you are
may I suggest this? Milords, I am for the husband,
Yeah,
Milords.
what?
Husband.
Milords, I am for the husband, Milords. My
Now
colleague is
now
there.
the question is, you see, if the parties are ready and willing to reconcile
Yes.
the differences, some time should be granted. But when they come into a fit mental state, they will be able to take decisions. So let this treatment, let the suit be adjourned. The suit can be deferred. So I fix another date. So
Milords,
that
But my lords,
Milords, I bow down to what is falling from your lordship.
Yes.
Milords, your lordship knows that the matter is now with the North Bengal Medical College and Hospital.
Yes.
Milords, you see the prescription, the doctor has recommended that let a medical board be constituted. What I am
Yes.
proposing, Milords, to your lordship, subject to what my friend also says, let there be a direction from your lordship that this medical board be constituted at the earliest, and let that medical board give a report to your lordships, Milords, so that further action can be taken in the matter. Milords, that's my humble submission before your lordship. Now,
I
Milords,
have no objection for that, my lords.
Milords, on these allegations, Milords, I agree with my learned friend that there is no point getting into these allegations, Milords. I was not present with the doctor at the time, neither my friend was present. Milords, the husband was present and the father of the Milords petitioner, which is the wife, was present. Milords, if they have an objection or reservation on these Milords comments, etc., Milords, they could very well, Milords, let the concerned doctor know so that he doesn't record any of this, Milords. But my understanding is, subject to correction from my learned friend, is that the doctor asked for some history, Milords. And that's how perhaps the husband has narrated all of this. Milords, the idea is not to make any allegations.
Yes, record an order. Learned advocates for the parties are present. Hard learned advocates. This application is directed against order dated 5/10/2024, passed by the learned additional district judge, First Track Court Siliguri, in MAT suit number 242 of 2024. By order dated 5/10/2024, the learned trial judge was pleased to allow the application under Order 32, Rule 15 of the Code of Civil Procedure, read with Section 151 of the said code, filed by the opposite party husband in the said proceedings. Stop. The petitioner wife, being aggrieved by the order passed by the learned trial judge, has come up with the instant application. Stop. During pendency of this application, there was mediation proceedings and the learned mediator in his report has observed that there is a chance of reconciliation, but the wife requires some medical attention. Stop. Thereafter, by order dated 26/11/2025, an order was passed granting liberty to the parties to consult any doctor of their choice. Stop. Learned advocate for the petitioner submits medical prescriptions wherein it appears that the petitioner wife was examined by doctor. In the said prescriptions, yes, in the said prescription, different observations are made by the North Bengal Medical College and Hospital, Darjeeling, Siliguri. It is further observed that this matter should be referred to the medical board. Upon perusing the prescription and the report submitted by the North Bengal Medical College and Hospital, this court is of the view that this matter with regard to examination of the petitioner should be before the medical board. Thus, this case is adjourned for a period of 2 months to enable the parties and their learned advocates to move the medical board in terms of the prescription dated 3rd December 2025 and to get the petitioner wife examined. The North Bengal Medical College and Hospital, Darjeeling, the superintendent of North Bengal Medical College and Hospital, Darjeeling, Siliguri, is requested to look into the matter so that the same may be expedited. Upon examination by the medical board, the parties, upon obtaining the report, shall place the same before the next available circuit bench, which is to sit after the period of 2 months. Liberty to mention after 2 months.
Grateful, my lords.
Grateful.
As the matter is sub judice before this court, parties may seek adjournment before the learned trial court, which may be considered.
Please, my lords.
Grateful, Your Lordship.
Obliged, my lords.
Eleven, I'm for the petitioners, my lord. Your Lordship kindly sees the order dated 7 November 2025, passed by Justice Basu. There was direction to upon the petitioners to rectify the classification of the said proceeding. And accordingly,
You are for the petitioner.
Accordingly, applications were filed for rectification of the probate case to letters of patent, my lord. This is the order, my lord, that has been allowed.
So this was the direction 7/11/2025
Yes.
that where your application under section 10,
It was the original challenge, my lord,
yes, that was dismissed.
dismissed. And Justice Basu was of the opinion that both these proceedings can be clubbed now in view of the order of this Honorable Supreme Court.
Yes.
So, while partition. Probate. But it was wrongly classified. It ought to have been letters of administration.
So there is nothing remains to be adjudicated in this matter now.
It has to be, madam. It has to be clubbed both the proceedings together.
Yes.
Classification has been changed now. This is the order that.
Anyway, that is dismissed.
No, that has been,
Yes.
what I have said, by suit, so this part, that is confirmed by the same order. What are dated 12 March 2025. Find the section.
Instead of staying the partition suit, both the proceedings can be clubbed together. That was the observation made by the Justice Basu. Presently, the letters of administration proceeding is pending before the learned additional court at Siliguri, madam.
Same court or different courts?
Siliguri, no, the both are, the partition suit is.
Different
before-
judges.
Yes, partition suit is before the civil judge senior division. So it has to be clubbed with the,
So that, for that, a district judge has to be,
it has to be clubbed with the.
district
proceeding
judge
taken
has to be
before the district
directed
judge.
to send it to the same court.
Yes, district judge. Yeah, it is pending before that, yeah, probate case.
It's better that be done by the district judge. Yes, record an order. Learned advocates for the parties are present. This application was filed against the order dated 12/3/2025 passed by the learned Civil Judge Senior Division Shiliguri in title partition suit number 8 of 2020. Stop. The petitioner, you are the petitioner defendant before
In partition suit.
the petitioner defendant in the said partition suit being aggrieved by the order passed by the learned judge dismissing application under section 10 of the Code of Civil Procedure has come up with the instant revisional application. During pendency of this application, a learned coordinate bench of this court was pleased to grant liberty to make necessary rectification in the probate case being number, what was the number?
Madam, probate case number. OC probate suit number 13 of 2023.
OC probate suit number 13 of
23.
OC probate suit number 13 of 2023, which is pending before additional district judge,
First track court, Siliguri.
first track court, Shiliguri,
Madam.
so that the same is treated as an application for grant of letters of administration. Stop. Pursuant to the order dated 7/11/2025, the parties took necessary steps, and it appears from the order dated 19/11/2025 that the petition made by the applicant, opposite party for converting the probate case into the letters of administration was allowed. Stop. Learned advocates relies upon the decision of the Honorable Supreme Court in the case of Balbir Singh Vasu versus Laghbir Singh and others, reported in 2005 bracket 12 SCC 503, wherein the Honorable Supreme Court was pleased to observe as follows. Set out paragraph 6. Upon hearing the learned advocates and considering the facts of the case and the decision of the Honorable Supreme Court relied upon, this court is of the view that the OC probate case number 13 of 2023 pending before learned additional district judge fast track court Siliguri and the title partition suit 8 of 2020 pending before learned civil judge senior division Siliguri should be heard analogously. Stop. As both the cases are before two separate courts, it would be just and proper to direct the learned district judge Darjeeling to assign these two cases to any particular court so that these are heard analogously. Thus, this revisional application stands disposed.
Since the senior division cannot take up the.
Whatever it is, if the learned district judge thinks himself that he himself will take up the matter, he may take it
It will
up.
be then difficult for both the parties. Both are from Siliguri. They have to travel to Darjeeling there.
Anyway, some other court, whatever he thinks fit, he will assign to any court, to assign the matter to any court competent. Two cases to a particular court competent to hear the same in accordance with law. Hear the same in accordance with law. Thus, this revisional application stands disposed. Stop. It is hereby made clear that this court has not gone into the merits of any of the cases and parties will be entitled to agitate all the relevant points before the learned courts.
The Honorable Supreme Court has clubbed the suit with the probate case.
Anyway, no, that has to be. That has to be. But instead of this court directing, let the district judge do it. Let a copy of this order be sent to the learned district judge Darjeeling for necessary steps.
By the same input order, by ad interim order of injunction was confirmed with that procedure.
No, that I've only prayed for this particular order.
Acha. It is also further made clear that this court does not vary or alter the order of the learned trial court, which was under challenge.
Which was not under challenge. We have not challenged the.
Whatever it is, I have not touched that order. Hmm. Yes.
We want to authorize this application.
Yes, you are for the petitioner.
Petition.
Yes.
Revisions.
Record an order. Learned advocate for the petitioner is present. Learned advocate submits that his client has instructed him not to proceed with this application. Thus, this revisional application stands disposed as not pressed. Yes, call the next.
Party.
Party.
Lordship, in this application, the petitioner, she is the plaintiff in the trial court, filed one suit for declaration, injunction,
Yes.
eviction
Yes.
of the defendant.
Yes.
The page number 36, annexure P2. Lordship, this plaintiff in the court below purchased a piece of land and building, which is the
Yes, what
subject.
is the order and the challenge?
Order 1, Rule 10 has been filed by the defendants after appearing before the court.
Okay, let me see. Yes.
Lordship, after appearing before the court below, this defendants filed the written statement and brought the pleadings in the page number 44. I am referring the page number 44 of the written statement, running page 44.
Yes.
1, 2, 3, 4, 5, 6, 7. Line number 7 stated that defendant purchased the property on 18/10/2017.
Para 7,
Line
line
number
7.
7. Yes. Page number 44.
page 44, that is para?
First paragraph, line number 7. 1, 2, 3, 4, 5, 6, 7. One date is mentioned there, 18/10/2017.
Yes.
The defendants purchased the property by virtue of one registered sale deed.
This is your plaint case?
No, this is the
Defend-
written statement
Okay,
filed
written
by the
statement,
defendants. Yes, I am only referring.
Yes.
This is the 18/10/2017, and I purchased the property. That is the document number 14, that page number 33, relevant page number 33. That is my sale deed.
Yes.
Presentation for registration on 17/10/2017. That
Yes.
is one day before. This is 17/10/2017, and as per the claim of the defendants, that was the 18/10/2017. However, the application filed by the defendants for adding the predecessor who sold the property to the plaintiff allegedly also sold the property to the defendants, a portion of the property to the defendants, and the entire property has been sold by the predecessor one day before to the plaintiff. That is the case before the court below. So the
Where is the application? Order
Application
128.
Lordship, page number 47. There is no allegation why the predecessor is the necessary party. After disposing the property, she
Just a
has
minute.
no interest at all in the property. She left the place. Lordship, in the para number 4 of that application, it is the admission of the defendants that the predecessor of the plaintiff. At best, she can be cited as the witness in that case. She has no right, title, interest after disposing the property either to the plaintiff or the defendants. The title deed which has been relied by the plaintiff and defendants, that's the matter of the scrutiny by the learned trial court. And the best title holder will be, that deed will be prevailed. What is her role in the suit? And after disposing in the entire property, she left the place. Now, if I'm not wrong, subject to the correction of this record, this predecessor is more or less 80 years old. I don't know after disposing the property whether she is alive or dead. Where I will search her. I have been given the direction by the court below to implement at the party. Why? That has not been given. Even also, my deed has not been challenged by filing the written statement. Only the claim before the court below by filing the written statement that the defendants also
No, you have
purchased the
stated
property.
Statements in para 1 and 2 is partly true in respect of transferring issue to land. And
Yes, it's an admission.
that is your written objection.
My
Your written
written
objection.
My written objection.
Para 1 and 2 is partly true in respect of transferring land. What is the ground of, no, what your suit is for?
Eviction. Declaration, eviction, consequential relief.
Yes, what is your? Paragraph 3.
Page number 47. Page number 3, not para number 3, na? Para 3.
You and your learned friend.
No, what is the statement that, Lordship, please see that reading, that for clarifying the property of the said transfer twice, the intention and reasonableness of the former owner regarding the transfer of the former owner in the essential of necessary party.
You see, a dispute with regard to property, both are.
Yes, this is the
it's a-
registered sale.
It's a valuable, you see, as
Nobody
a-
is denying
so many-
regarding their
many
respective
par-
title deed.
right of the persons are involved,
Lordship,
okay?
both the
It
deeds are
cannot
the
be
registered
taken-
one. Both the deeds are the registered one. Registered sale deed is not required to be proved in that manner. Nobody is denying regarding
Okay,
the
what
existence
decisions
of
you
the deed.
relied upon?
Lordship,
What decision you relied upon? That is, okay, there are some decisions. Only the necessary and proper party. This person may not be necessary party, but he may be a proper party.
proper party that she can be cited as the
No, what
witness.
is the difficulty?
Lordship, after disposing the property, that old lady left the place. I don't know regarding her
Because there
whereabouts.
are rival claims with regard to a particular property.
So the title deeds are there. That was the
Maybe
registered.
So,
If I will hold the better title, for the sake of argument, I am giving the passage to the defendants. If the defendants will hold that better title, in that case, the deed will
No,
be.
question is, you see, if that person from whom the right comes,
Yes, Lordship.
that person can be examined, the court can.
Yes, can be examined, but the necessary, why the necessary,
Better
party?
No, question, let him say whatever facts. That means you will not be claiming any right against him. He will be a pro forma defendant. Probably you will not claim any right against him, any declaration.
Nothing. I have no claim. Even also defendants also have no claim regarding the against the defendant. Even also single iota of allegation against her.
Yes,
Why?
I got an order. Learned advocates for the parties.
Liberty may be given to cite her as
Yes.
witness.
So again, you see that 80 years old, he has to come.
Sir, I don't know her whereabouts, Lordship. It will be
But
very
it is
harsh to me.
paper publication has to be made. Learned advocates for the parties are present. This application is directed against order dated 6/11/2025, passed by Learned Civil Judge Junior Division Shiliguri in TS 19 of 2018. Stop. The petitioner being aggrieved by the order passed by the learned trial judge in allowing application under Order 1, Rule 10(2), read with Section 151 of the Code of Civil Procedure, by adding the original vendor of the original owner of the suit property, as former owner of the suit property, who is the vendor of the plaintiff in this instant suit. Learned advocate for the petitioner submits that once the property is disposed and the plaintiff has become the owner of the said property by virtue of that sale deed, the said person has no role to play in adjudicating the dispute with regard to the said suit property, which is already transferred. Top. Learned advocate for the defendant submits, learned advocate for the opposite party, defendant submits that his client also purchased the suit properties from the self-same person, and thus the presence of the said person is necessary. Stop.
The stamp duty was paid after the actual measurement. That is in the month of December.
Okay. And the stamp duty was paid after the actual measurement.
After the deed executed.
After the deed was executed in favor of the defendant. Stop. Upon perusing the order passed by the learned judge, the courts have power under Order 1, Rule 10, within bracket 2 of the Code of Civil Procedure, to add necessary and proper parties. Order 1, Rule 10, within bracket 2, provides that the court may at any stage of the proceedings, either upon or without the application of either party, and on such terms as may appear to the court to be just, order that the name of any party improperly joined, whether as plaintiff or defendant, be struck out, and that the name of any person who ought to have been joined, whether as plaintiff or defendant, or whose presence before the court may be necessary in order to enable the court effectually and completely to adjudicate upon and settle all the questions involved in the suit, be added. Stop. Upon perusal of the provision, it appears that a party in the suit may be necessary or a proper party, and courts, if it thinks fit, may implead a party at any stage of the proceedings. As the nature of the suit involves rival claim by both the plaintiffs and the defendants with regard to the said property, and the right of the said property flows from a particular person on the basis of the conveyance deed, it is necessary that this said person should be implemented as a party. Thus, upon considering the facts of the case, this court is of the view that there is nothing infirm in the order passed by the learned trial judge. Thus, the order passed by the learned trial judge on 6/11/2025 is affirmed. This revisional application is disposed. Stop. However, as this suit is pending from 2018, learned trial court is, trial judge is requested to dispose of the suit very expeditiously and preferably within a period of 6 months from the next date fixed without granting any unnecessary adjournment.
Lordship, one paper publication that may be given the direction. please.
As it is submitted
No,
by
no,
the
no, no.
learned
18 থেকে আমরা পড়ে
advocate for the plaintiff that it is difficult to serve in the ordinary courts, the added party as
Lordship,
because
as the instruction is given by my client.
as the added
that the-
party,
that
as
the
he has
lady-
left that area.
That the lady is now residing at America.
Okay.
It's a 2 years back, this
whatever it
information.
is.
How I will serve the copy, this will be very hard for
She
me.
was residing in North Bengal previously.
Lordship.
Acha. The question is, as it is submitted by the learned advocate for the plaintiff petitioner, that it will cause difficulty to cause service upon the added party in the usual courts, as because he is not residing in that said place. The plaintiff petitioner is granted opportunity to make necessary paper publication.
Lordship, deeply honest. I have no problem if anyone will come before the court. What is my problem? Nothing should be go
The
behind
paper
the back.
publication
Yes.
and also to make affixation of notice in the place where he last resided.
That the residence has already been disposed of.
Okay. And in the place should of the notice in the residence where which appears in the voter identity card.
Okay, Lordship, no problem.
Both voter identity
Both,
card
both,
address,
both,
affix that notice
Both.
and that paper publication.
Deeply obliged, Lordship. Deeply. Grateful.
Lordship, item 40, I'm paying for an adjournment.
Okay, not today.
Not today, Lordship.
Lordship, I am for the petitioner.
Okay, tomorrow.
Hello.
Item 15.
Lordship, item 15, I beg to appear on behalf of the opposite party.
16 yesterday I paid for Monday, madam. Thank you.
Okay, 15,
Lordship,
16, not
15
this
is,
week.
15 is, Lordship, pending for more than 2 years, Lordship.
Okay, not this week, 15 and
Then kindly
16.
fix it on Monday, Lordship.
Yes, not this week means Monday.
Greater.
17.
Lordship, I'm for the petitioner. Lordship, earlier I'm also free for this matter to fixed on Tuesday, Lordship, kindly. Next week, Lordship.
Not this week.
No, next week.
Monday, my lord.
I'm making it not this week.
I'm for the opposite party.
18.
Grateful.
18, not today,
19.
not today,
20.
not today,
22.
not today. I'm making it not today. I don't know whether I can. 22,
For the closure. And the opposite party.
petitioner is not here.
They are not appearing.
Okay, not today.
Look, I did. They sent them at the next circuit. They will not appear. Can you
Okay, let us see.
23.
My lord, in this matter, I am appearing on behalf of the opposite party petitioner, my lord. Yesterday, the matter appeared. I had prayed before your lordship that
Learned Senior Counsel Shoptangshu Pasu will be appearing today, but due to some difficulties of his, he hasn't been able to appear.
Okay, not this week.
My lord, he has requested your lordship to make it next circuit, my lord, if it's possible, my lord.
Yes.
I have also informed my learned
Okay,
friend.
record and order. On the prayer of learned advocates, the matter be posted in the next circuit.
Deeply obliged, my lord.
Not today.
26,
Yes, same, not today.
28,
Not today.
29,
For admission of the first appeal. Against the judgment and order passed by the motor accident tribunal at Siliguri.
So you are the claimant appellant.
No, I am the respondent.
You are the
Respondent
insurance
owner.
company.
Respondent owner.
Yes. So award was passed against you.
Yes, ma'am.
So if you want to stay, you have to secure that amount. You have to deposit this
Yes,
amount.
ma'am. Kindly admit the appeal, ma'am.
No. You see, I can admit, you see, this is a statutory appeal,
Yes,
but unless you deposit this amount, there cannot be a stay of this order.
yes, ma'am. And once the appeal is admitted, ma'am, we will prefer an application for stay. At that time, we will deposit the secured amount.
Yes, record an order. Learned advocate for the appellant is present. As this appeal is preferred within time, the same is admitted. The appellant is granted liberty to file application for stay upon payment of the statutory amount of rupees
Grateful.
25,000.
Much.
Let the matter appear in the next circuit.
Hello, yes. Much grateful.
30 item,
30 key defect আছে. Yes. 30 who is okay, नहीं, अच्छा, not today.
31,
Not today.
32,
Yes, not today.
33,
Lordship on 18th.
Yes,
I'm paying for fix the matter on 18th.
18.
Yes.
Yes. Record an order. Let this matter 18th. Okay, not today and tomorrow.
18th, Lordship.
18th means Thursday.
Yes, as
Not-
because several matter on fixed on that
Okay,
day.
I'm making it not today and tomorrow means 18th. अच्छा, record করে নিন তো, let this matter appear on 18/12/2025.
Grateful, Lordship.
Not today.
35,
You are for the appellant insurance company.
Yeah, I have the appellant insurance company.
Yes, what is the defect?
Defect.
Have you taken up any application for stay?
Yes, Lordship. No, Lordship. I have deposited the 25,000 statutory deposit,
So without application for stay, how the order will be stayed?
court may grant.
Anyway, record, let me see. Take
Court may
it.
grant the stay, and in the meantime, I shall file the stay application.
Yes, record an order. Learned advocate for the appellant is present. As the appellant insurance company has paid the statutory amount of rupees 25,000, there shall be an interim order of stay of the judgment and award dated 31st January 2025, passed by Learned Additional District Judge, First Track, First Court, Jalpaiguri, in MSC case number 170 of 2017 for 170 of 2017.
16.
It is here 17 in the judgment. Then maybe. In the impugned order, it is
7.
yes 17 for a period of 5 weeks from date. The learned, yeah, the appellant shall take steps to deposit the entire awarded sum within the period of 5 weeks as directed by the appellant insurance company shall take steps to deposit the entire awarded sum along with interest, excluding the statutory amount within this period of 5 weeks. Top. Liberty to apply for extension of interim order by making necessary application for stay. So make an application for stay, it will be extended.
But liberty to correction of the defect.
Yes, liberty is granted to correct the defect. Very good.
I'm on the airplane. There is a delay. I need to take up a.
Have you served
No.
the delay application?
No. We have not.
Yes, record an order. Learned advocate for the appellant is present. Let the copy of the application for condemnation of delays served upon the respondents. Let this matter appear on 22/12/2025.
Sure.
Not today.
38,
Not today.
39,
Same, not today.
40,
Lordship, kindly allow the not today.
Not today.
41,
Not today.
42,
Not today.
43,
Yes, 43.
Of the
I beg to appear for the insurance company, Lordship, in this matter.
and affidavit of service, and my uncle's submission is that. Kindly
No,
take-
question is, this paper books are to be filed. It is within the limitation period. Okay, the paper books are to be filed. You are for the appellant.
Yes.
So there is no pending application to be disposed.
I'm for
Yes.
the insurance company, Lordship, in this matter.
So you are challenging the quantum as awarded by the trial court.
Yes, Lordship.
Okay, record an order. Learned advocates for the parties are present. Let the paper books be filed within 4 weeks. Let informal paper book be filed within 4 weeks, and the matter be placed before the next available circuit.
Insurance company. This is
45,
But not today.
item number 40, number.
I made it not today. Come tomorrow. Not today.
47,
Yes, not today.
48,
Not today.
49,
Not today.
50,
Yes, not today.
51,
51.
The insurance company, I am not the appellate here. He is the appellate here.
Yes, why defective? Can one issues application
Here is my application
for?
for delay, condemnation of delay.
Okay. Yes. What is the period of delay?
Actual delay, Lordship, 1 year, 10 months, but including the COVID period.
No, when was the award passed? Okay, 2018.
Reviewed service.
So both the insurance company and the vehicle owner.
Yes, Lordship.
Yes. Can one টা দেখি ওটা এটা Filed in 2021. Yes, not 21 during COVID period. Yes, what do you say?
With objection.
Yes, record an order. Learned advocate for the appellant claimant and learned advocate for the opposite party respondent number one insurance company are present. The application for condonation of delay being Can 1 of 2021 is taken up for consideration. Heard learned advocates. It is the contention of the petitioner that due to personal difficulties and the COVID period, this application, the appeal could not be filed in time. A learned advocate appearing for the respondent number one insurance company objects to the prayer. Upon perusing the petition and considering the grounds furnished, this court is of the view that in the interest of justice, delay should be condoned. Thus, delay in filing this appeal is condoned. The appeal is admitted. The appellant is directed to take steps to file paper books within. Let informal paper books be filed by the appellant within 4 weeks. The trial court's record to be called for at the special messenger cost to be paid by the appellant. And let this matter be placed before the next available circuit thereafter.
Liberty charge, defect clear.
Liberty can be granted for clearing the defect.
Achha. The affidavit of service filed be kept with the record. And yes, what is the defect there? কি ডিফেক্ট আছে দেখি রেকর্ডটা এটা oh it is filed out of time. The note marking the matter as defective be removed. Can is dismissed.
I've heard that already. In this case also 160 days delay, actually during the COVID period, it to be
So
calculated.
where is the insurance company?
This company,
Have you served?
yes, yes.
Yes, where is this application? Order was, the judgment was passed when? Award passed? Yes, record an order. Learned advocate for the appellant is present. None appears for the respondents in spite of service of notice. Stop. Let the affidavit of service filed be kept with the record. The application for condonation of delay is taken up for consideration. Heard, learned advocate for the appellant petitioner. Peruse the petition filed. Upon perusing the petition and upon hearing the learned advocates, this court is of the view that the explanation of delay is sufficient. Thus, the explanation is accepted and the delay is condoned. Can 1 of 2021 stands disposed. The trial court records be called for at the special messenger cost to be paid by the appellant. The informal paper books be filed within 4 weeks upon arrival of the trial court records, and the matter be placed before the next available circuit.
The matter will be fixed on Monday. We will withdraw this appeal. because
54.
Lordship,
Okay, not this week.
on this one.
55,
Not today.
50,
Not today.
61, 62.
Lordship, before the appellant, Can two is existing. Can two actually we filed one petition. Both in both appeal we filed for demise of one petitioner in tribunal for substitution of added.
Oh, can 2 is your application.
Yes, that has been disposed of. That actually can 2 is defective. That was I filed can 3. Can 3 allowed, but can 2 is running. That has to be dismissed.
Okay. So can 2, the application can 2 is disposed, so let it go out of the list.
Yes.
Okay, and then with regard to the second one, FMAT 79 of 2024, there are both can 1 and can 2.
Yes.
Both are all disposed.
That is for stay.
Okay, that is a separate.
That is separate.
Okay, that is, so let me take up this one, that is can 2.
Can 2 of my.
Yes,
Appeal-
no,
app-
FMAT
appellant-
MV
eh,
79 of 2024.
No. Can 2 of FMA 50 of 2025.
FMA 50.
Yeah.
Where is this? I find item 61, Shikha Saha.
Ashika sir.
FMA
Two item.
Okay,
51,
item
62.
Item 61, you are the appellant.
I am the appellant.
You are the
Insurance company.
respondent insurance company, item 61.
Lordship.
Okay. And here can 2 is disposed.
Can 3 is disposed of by adding the parties.
Okay.
Can 2 is defective.
Now,
That is why I am not pressing the.
from the self-same award, two appeals have been filed. So one is your appeal, 61,
Yes.
and the other
Another is
62.
insurance company.
National insurance, two vehicles were there, two vehicles collided.
So from the self-same award, two appeals have been preferred.
Lordship.
So in so far 61 is concerned and 61, it is your appeal.
It is mine.
So paper books have to be filed.
Everything
Paper books filed.
fine.
Okay.
It can be hard, Lordship.
Yes.
Just we that can 2 is running. That is the defect only.
Okay.
That
So,
that I am not pressing.
so let us take up this FMA 50.
Lordship, both can be heard together, but another insurance company lawyer is not representing.
Oh,
Supriya Singh.
that
She
that
represents.
application is to be heard out also, can 2.
Both the appeals should be hard.
Appeal can be heard together.
Okay, I'm just making it not today.
Lordship, one order is required that can 2 running in my appeal.
Yes, record an order. Learned advocate, এটা প্রথমটা,
I am not pressing, yes.
sixth one. Learned advocates for the parties are present. Can 2 of 2025 is disposed, let it go out of the list. Stop. Next, FMAT MV 79 of 2024. As the learned advocate for the appellant is not present, the matter stands adjourned till 18/12/2025. Day after tomorrow.
Lordship, both should be heard together.
Yes, both.
Lordship, grateful Lordship. দিচ্ছি।
Lordship, I'm paying for 1 day accommodation.
Not today.
68.
One day accommodation.
Not today.
22.
Lordship, I'm paying for 1 day accommodation.
Yes. Not
Paying
today.
for not today.
Not today.
73.
73, who is appearing? Okay, not today.
54.
Not today.
25.
Not today.
37.
Not today.
28.
My lord, in this matter, I'm appearing on behalf of the opposite party, my lord. There is a section 5 application, my lord. There is a delay of 4.5 years. And section 5 application has not been served, my lord, upon us.
Yes. Who is appearing for the appellant?
No, he doesn't appear, my lord.
I'm just making it not today. Let us see tomorrow.
My lord, let there be a direction to serve a section 5 application so that we can file an opposition to that.
Yes, record an order.
70.
Learned advocate for the. Huh? Huh? No, learned advocate for the respondent is present. Let a copy of the application under section 5 be served upon the respondent. Let this matter appear on 22/12/2025.
My lord, there be a liberty to file an opposition to the section 5
Yes,
application.
liberty is granted to file affidavit in opposition.
My lord, let the matter be in the next circuit because it will, I have to take instructions.
Anyway, let it appear on 22/12. Thereafter, I shall grant you liberty.
Deeply often.
79.
Not today.
80.
Respondent number 1.
Respondent number 1. Okay, this is an application for condonation of delay.
Yes, my lord, and there was on
How much is the delay?
about 1100 something days, my lord, and on 7th of November 2025, the Honorable Coordinate Bench was pleased to direct us to file the affidavit in opposition in 2 weeks, my lord. My mistake, I could not do. I'm just praying for an extension of that time, my lord.
Okay, record an order. Learned advocates for the parties are present. The time to file affidavit in opposition to the application for condonation of delay stands extended for a period of 2 weeks.
Great,
Let this matter appear before the next circuit.
grateful, my lord.
Respondent one.
81.
Okay, not today.
82.
Not today.
84.
Yes, not today.
85.
85.
Better, I'm appearing on behalf of the appellant.
Yes, it is ready.
Yes, I'm.
Yes, give the paper books.
Lordship, I have just received the paperwork, let it be fixed on Monday. Just that.
Acha, record order. You cannot get ready this week
Monday, they have other matters with them also.
because Monday definitely I'll take it up, but few days will be left. Acha, record an order. Learn it. advocate for the parties are present on the prayer of learned advocate for the respondent number one insurance company. The matter is.
Lordship, if it is speak for Friday,
Huh?
if it is possible, if it is speak for Friday, on Friday.
Your learned friend wants Monday.
Tuesday কর তাহলে
Yes,
his senior will not will then Tuesday.
I'm keeping it on Friday.
Lordship.
Let this matter appear on 19/12/2025 at 4 p.m. Not today.
88,
Not today.
89, 90,
90, 91, 92, 94, these four are analogous case. LCR, it is admitted, but LCR has not come. LCR.
Oh, this four. You are for the appellant.
Appellant.
All the cases.
90, 91, 92, 93.
So paper books are also not filed.
No, but since LCR has not come.
Yes, record and order. Learned. So let the LCR be called at the special messenger cost.
We will pay.
Yes.
We will pay special.
Yes, learned advocates, সবকটাতে এক order করে দেবেন. Learned advocates for the appellant is present. The trial court records be called for at the special messenger cost to be paid by the appellant. Let this matter appear in the next circuit.
Appellant.
Lordship, I am for the appellant in
The matter is ready for hearing.
ready,
Paper books are filed.
filed.
Insurance company.
Lordship, he would appear in virtual mode. Just take talk with him. May I take short pass? May I call him?
Okay. Pass over.
That item, Lordship, I am for the claimant, insurance favor and the appeal. The direction to make payment to the register.
96.
96.
Prior court records have come.
Books
Books are also ready.
already. Your Lordship can fix on any day, Friday or.
I'm just making it not today.
Yes, yes. And a direction where the petitioner appellant should be remain present on that.
Let us see tomorrow.
Lordship. লাগবে না।
97, 98,
My lord, kindly keep the matter on Friday as the learned advocate for the insurance company will be available on Friday.
Yes, let this matter appear on 19/12/2025.
My lord, also item number 103 is also.
Wait.
with this-
$99,
Not today.
101,
Not today.
103,
My lord, kindly keep the matter on Friday.
Yes, let this matter appear on 19/12/2025. $104. No, not today.
105.
I am appearing for appealing.
Yes, who is for the insurance company?
Your Lordship, I'm waiting for item number 94, not 104.
94, I have adjourned it,
I think
probably.
it's a passover.
Oh, I have passed it over.
Yes, yes.
Okay, please call 94.
For an idea, one appeal filed by claimant and one appeal filed by insurance company.
94 is your appeal.
94 is
And 95 is a separate appeal by the
separate appeal
insurance
by the
company.
insurance company.
What is your ground of challenge?
Yes, the income assessed by the Land Tribunal, rupees 7651 per month as an unskilled labor, but actually he's a agricultural.
How much was the quantum of income assessed?
9,000 we paid actually per month.
No, question is, let me see.
And insurance company.
So 15 lakh was claimed.
Lordship.
Yes. So he is an agricultural farmer or whatever. There cannot be any fixed wages, minimum wages. So whatever the learned tribunal thought fit, yes, learned tribunal.
Actually, sir, Lordship, actually, the income now comes at least 500 per month. Used to, but we paid only 300 per day. That is the my submission. And agricultural products does not attract income tax. That is why you have no income tax return. So we could not produce the same. That is the issue.
So what is the income considered?
7651. Our prayer is 9,000 rupees only.
Your Lordship,
another issue, another ground, Lordship, that is interest given from the date of award, that would be from the date of application.
If your Lordship allows me, then I can submit my point of view in respect to this appeal, Your Lordship. Your Lordship, in this appeal, the insurance company has got a very limited prayer before your Lordship today. If your Lordship kindly come to the judgment once. This is the judgment which has been passed ex parte against the insurance company, Your Lordship. The running page of the judgment, page 30, Your Lordship.
Page 30.
30 of the impugned judgment, Your Lordship.
30, yes.
Your Lordship will find out that the instant claim petition B and the same is allowed ex parte against the insurance company.
Just
paper book 30.
No, running page 30.
Lordship.
Of the judgment. Running page 30 of the judgment, Your Lordship.
Yes.
the instant claim petition B and the same is allowed ex parte against the
Fine.
go digit.
T0 is only the discussion of the Sharola Verma case, then the multiplier theory.
Your Lordship, in the top in the judgment in the
Paper book.
top there is
Paper book 46.
paper book 46. Paper book 46. Your Lordship.
Yes.
So Lordship will find out that this judgment has been passed in the case ex parte against the insurance company. Though the insurance company has got two-fold points which needs to be adjudicated and in which the evidence needs to be adduced by the insurance company. Though we succeed or not, that's a different story, Your Lordship. But we should be given a fair chance to at least contest.
From your side, there was cross-examination.
Cross-examination was there, but we haven't filed the written statement, and everything was the ex parte against us.
No, unless you file written statement, how the were framed. Immediately you file written statement.
No, Your Lordship, nothing has been filed. Your Lordship will find this an ex parte order, Your Lordship. If we have filed the statement, then we could have contested the matter. Your Lordship, kindly come now to the page 3. Page 3 means, Your Lordship, the running page. Running page 19, Your Lordship. Para 13, Your Lordship. Running page 19, para 13. The owner.
Yes.
The owner of the vehicle OP number 1 had appeared before the court but did not contest the case, and the insurance company Go Digit General Insurance OP2 did not appear before this court after receiving the summon, and the same is proceed ex parte against both the parties. So we have not done anything in this matter.
There was no scope of any cross-examination.
Nothing. So my humble submission is.
No. Why didn't you file an application for recalling that ex parte award?
We have done so, Your Lordship. That was also been rejected, Your Lordship. That will be. Your Lordship, kindly come.
18. Paragraph number 9. Running page, paper book 18. Paragraph number 8. 8 and 9. Several opportunities were given, but they didn't turn up. That is why court matter expertise rejecting their petition.
Your Lordship, my today's submission in respect to this appeal is, if Your Lordship kindly remand this back to the lower forum for giving us a one chance to just put forth our argument and to conclude the hearing in time-bound process. I bow down today before Your Lordship and says whatever time frame Your Lordships give us today will be the sacrosanct for us, and we will take no adjournments further. Without any adjournments, I just humbly pray today that this matter should be remanded back to the lower court to get, so that insurance company get a fair chance. Your Lordship, before Lordship decides that also, I need to point out what are my grounds which I have not able to take before the learned lower court below. Your Lordship, the two grounds which are very important, Your Lordship, is we cannot substantiate our point before the learned lower court. The fact is, the person who has died from a tractor. He is the non-gratuitous passenger for a tractor, as Your Lordship is well aware that in a case of a tractor, only one person capacity is allowed as per to the rules prevalent in respect to the roads and all. Your Lordship, in this case, there are two passengers. He is not a driver to the vehicle. He is the gratuitous passenger. So, Your Lordship, that is the first one. And in respect to also the income of the deceased, that also we cannot take the point. We may have a good case if we could prove that the income should be to a notional income of the victim. We also couldn't take a point. Your Lordship, twofold, 2-3 grounds are there, Your Lordship. Your Lordship, kindly remand this back in a time-bound process. If Your Lordship, any time, whatever time Your Lordship gives us without any adjournment, that I undertake today before Lordship, Your Lordship, the company will do it at any point of time, Your Lordship. I kindly remand this back. Because in this stage, I cannot put forth any grounds of appeal before Lordship.
Your Lordship, and it may be considered what they are submitting, it may be considered by this honorable court, and actually the accident took place long back, and the petitioners appellants are suffering. They are very poor.
Your Lordship, this is the case of 2024. Your Lordship.
Ready and willing to settle this matter.
Lordship, this is
Your Lordship, it cannot be settled because there is a we can settle if whenever there is an income dispute or something like that. Your Lordship, there is a dispute of non-gratuitous passenger. We have to take this difference, and if the order comes up against us, then we could pay it, Your Lordship. That's the difficulty we are facing. That is
Learned advocates for the parties are present. This appeal being FMAT MV 33 of 2025 is preferred by the claimant appellant against the judgment and award dated 25/11/2024 passed by the learned district judge Alipurduar in MAC case number 29 of 2024, and the appeal FMAT MV 9 of 2025 being preferred by the Go Digit General Insurance Company Limited against the ex parte judgment and award passed by the Learned Trial Court on 25/11/2024 in MSC case number 29 of 2024. The appellant claimants being aggrieved by the quantum of compensation awarded by the Learned Trial Court has come up with the instant appeal. Stop. However, instant appeal, this one.
33.
FMAT MB 33 of 2020.
FMA 33.
FMA, it is given as FMAT.
Sorry, what FMA?
FMAT MB 33 of 2025. And the appellant insurance company has preferred this appeal FMAT MB 9 of 2025 being aggrieved by the ex parte award passed by the Learned Trial Court. Learned advocate of the appellant insurance company submits that his client did not get any opportunity to file the written statement, nor did he get nor did they get opportunity to cross-examine the witness of the claimants and also to
argue
the matter. It further appears that an application for recalling the order fixing the case for ex parte hearing was filed by the appellant, but the same was dismissed. Upon perusing the judgment and award passed by the Learned Trial Court and also the materials on record, this court is of the view that when an application for recalling the ex parte order, fixing the case for recalling the order fixing the case for ex parte hearing was made, the said application ought to have been considered, and the insurance company which is functioning for the public interest ought to have been granted opportunity to contest the case. Thus, in the facts and circumstances, this court is of the view that the judgment and award passed by the learned trial court should be set aside, and the insurance company should be granted opportunity to file written statement and to contest the case upon payment of costs. Thus, the judgment and award dated 25/11/2024 passed by learned District Judge Alipurduar in MACC case number 29 of 2024 is set aside subject to the payment of costs of rupees 25,000 to the claimants within a period of 4 weeks. Upon payment of the costs within the period of 4 weeks, learned trial court shall adjudicate the claim case on merits. Stop. In the event the cost is not paid, then within a period of 4 weeks, then this order shall stand recalled. This appeal stands disposed. It is, however, made clear that this court has not gone into the merits of this appeal, and all points will be kept open to be agitated before the learned trial court. Yes, set aside subject to the payment of costs of 25,000.
No.
Great.
Your Lordship, all can applications to be
Yes,
disposed of.
I have disposed the appeal.
Okay.
So on condition that you pay the cost within 4 weeks.
I deeply agree. I'm deeply
And all points are kept open. This court has not gone into the merits.
Your Lordship, all can applications also to be disposed of, connecting applications.
Yes, all interrogatory applications stands disposed.
Deeply obliged, Your Lordship, deeply obliged.
Not today. Not today. Not today.
Fee and recovery funds.
Yes, it's better you argue. I'll hear your arguments.
Okay.
But better you go through this decision.
Okay.
Thereafter, I shall consider your submission. Will you take it out or shall I give you this copy?
If
Xerox করে দিয়ে দেবেন তো?
হ্যাঁ,
Xerox করে দিয়ে দেবেন। I'm keeping it day after tomorrow. এটা Xerox করে দিয়ে দেবেন, কপিটা আমাকে ইয়ে করবেন। Then you make your submissions whatever you want.
Okay.
Yes, not today and tomorrow.
Only one point is there in the appeal.
Yes, who is for the insurance company?
Mr. Rishin Chakraborty.
Yes.
The only point is that, Lordship, no
Let me
interest
see
has
this.
been granted by the tribunal.
Yes,
No interest has been granted by the tribunal.
let me see. Yes, where is this order?
Lordship, order. My paper.
Yes.
Order portion. The conditional interest is applied if the insurance company did not pay the amount within 60 days.
no reasons assigned why he will not get the interest from the date of filing.
Yes.
So this is only your ground of challenge. Yes, what do you say? So, yes, record an order.
We have
already deposited the total amount and they will already withdraw the total.
I am praying for interest at the rate of 9% or as per prevailing bank interest as per IB.
Learned advocates for the parties are present. This application, this appeal is directed against judgment and award dated 26th day of February 2020, passed by Learned Additional District Judge, Second Fast Track Court, Jalpaiguri, in MSC case number 242 of 2017. Top. The ground assailed by the appellant claimant in this appeal is that the learned trial judge, while awarding compensation to the claimant's appellant, have not awarded interest from the date of filing of the case till date of realization. Top. Upon perusing the judgment and award passed by the learned trial court, it appears that the learned trial court disposed of MSC case number 242 of 2017 by observing and directing as follows. Hence, it is ordered, set out for the bill. Thus, upon perusal of the order passed by the learned trial court, it appears that the learned trial court has not awarded any interest from the date of filing of the claim case till date of realization. Stop. Heard learned advocate for the appellant and learned advocate for the respondent number 1 insurance company. Peruse the materials on record. Learned advocate for the appellant submits that the learned trial court erred in not awarding any interest on the compensation from date of filing of the claim case. Stop. Learned advocate appearing for the respondent number 1 insurance company objects to the submission made by the learned advocate for the appellant. Stop. Before proceeding to decide this issue, it is necessary to consider Section 171 of the Motor Vehicles Act 1988. Stop. As per Section 171 of the Motor Vehicles Act, where any claims tribunal allows a claim of compensation made under this act, such tribunal may direct that in addition to the amount of compensation, simple interest shall also be paid at such rate and not from at such rate and from such date, not earlier than the date of making the claim, as it may specify in this behalf. Stop. Specify in this behalf. It is also held in different judicial pronouncements that grant of interest is the law and refusal is the exception, and tribunal, while refusing to grant interest, shall accord specific reasons when the claimant is responsible for delay in disposal of the case. Top. In the instant award, nowhere it appears that the learned trial court has assigned special reasons for not granting interest, and also there are no reasons that the claimant appellant is responsible for the delay. Top. Thus, the judgment and order passed by the learned trial court should be modified. Stop. Thus, this appeal is disposed. The judgment and award passed by the learned additional district judge, second fast track court Jalpaiguri, on 6th day of February 2020 in MSC case number 242 of 2017 stands modified to the extent that the respondent number 1, what is the name of the insurance company? New India. New India Assurance Company Limited shall pay interest at the rate of 6% per annum on the awarded sum from the date of filing of the claim case till to date.
No, June. We have already paid the amount before the, till the date of actual payment.
No.
But no interest has been paid.
Just a minute. Pay interest at the rate of 6% per annum only.
Only.
Other than the principal sum, only the interest. From the date of filing of the claim case till to date.
How, let's say, till they have already enjoying the money. I have enjoyed the money. We have enjoyed the money, but we did not pay any interest. Interest portion till the date of actual payment to the before the time shift.
No. See, interest in all cases, you see, in other matters in Calcutta I have awarded with regard to interest means from the date of filing of the claim case till the date per order, you see, this % of interest, okay. Regarding the principal amount you have deposited. Okay.
Yes, they are enjoying,
yes,
they
yes,
are
yes.
getting the interest of that amount.
Now with regard to the interest amount, they are not they did not get this interest.
Interest till that date, where the insurance company had paid the deposit. After that, they are enjoying the money, they are getting the interest.
Oh no, the principal, from the date of filing of the claim case till the date of deposit of the principal sum. Such payment shall be made within
5 weeks.
Within
4 to 5 weeks.
5 weeks from the date of communication of the order. This appeal stands disposed.
It should be still today, till the date of payment of it.
You see, the moment the principal sum is deposited, interest stops running. That is the thing. The moment they have deposited the principal sum, interest stops running. So they will be liable to pay the interest from the date of filing till the date of deposit of the principal sum.
I have gone through your last judgment in according to agricultural income.
Which case?
You have passed this judgment in 9th, actually, in principal bench.
No, in this the judgment which I gave you today.
No. I have seen whether the agricultural income or the income tax return. Which?
No, income tax. That is the authentic source. Yes, for farmers that don't have income tax return. For farmers, you have to depend upon some documents and this oral evidence, whatever it is. But for businessmen and professionals, they have their income tax return. So that is the authentic document.
We are referring this judgment now in
Yes. When this victim has filed this income tax return prior to his death, it cannot be altered or manipulated. So for professional and businessmen, always income tax return. Farmers and agricultural person, yes, they don't file income tax return, whatever they submit, they have to accept.